Hey folks, James Abrenio coming to you today. Again, thank you for coming to the podcast. Today is January 13, 2026. We are a day before the Virginia General Assembly starts its session tomorrow, Wednesday, when things start rolling. Today I've got a really interesting guest, Kristi Kelly. She is a well-known consumer protections attorney here in Fairfax, Virginia, but she's known throughout the state. I'm going to put, Kristi, I'm going to put a couple links of big stories you've been involved in. I'm a big fan of Planet Money. If you're a listener and you're a nerd, you're probably watching this. Planet Money is a good economics podcast. But one day I'm listening and I hear Kristi talking about zombie mortgages because she was involved in pretty serious litigation there and getting great results. She also just reached a huge class action settlement of close to $500 million dealing with essentially overcharging. And I'll let you, if you want to, get into a little more details about that, overcharging loans and things like that. And I think dealing with Native Americans, right? Is that what was going on there?
Yeah, it was dealing with actually individuals behind the scenes that were using a Native American tribe to evade state lending laws. Yeah.
Sure. And I'll put a link to the show notes in that as well, and you can contact her directly. But the main reason, Kristi, I wanted you here this morning, and I appreciate you coming on, is to help us understand class actions here in Virginia. What's the purpose of them? And just for context, they are trying to push through in this session class actions. I'm not even sure if the bill's been pre-filed yet. I think it has. But I really wanted, Kristi, you to kind of give us a 101 on class action. So why don't we start kind of from the 1,000-foot view? What is a class action, and why is it important here in Virginia versus why isn't it just good the way it is in the feds?
So a class action allows a consumer or an individual or an entity to bring a case on behalf of themselves and others that would have the same situation happening. And so it would provide global relief for the same practice that would have impacted numerous consumers in the same manner. And so it is particularly important as a consumer lawyer because many people can't afford lawyers. And it's particularly important when there's like smaller dollar claims, like a $50 junk fee on every month rent. Like, do you hire a lawyer to seek redress for it? Or, if you are able to bring that on a class-wide basis, the $50 adds up over the course of like 5,000 people that have been impacted. And so that case can have much more meaningful relief. And so from my perspective, it's important because it's an access to justice issue for people that may not have access to a lawyer, but a lawyer with one client can get relief for all consumers in a class action.
Why is it that we need this in Virginia? Because I understand there's federal class actions. Why isn't that sufficient?
So Virginia is actually one of only 2 states in the country that don't have the procedural mechanism for class actions. The other state, I believe, is Mississippi. And so it is, not all claims can be brought in federal court. And so there are some claims that aren't federal claims that enforcing Virginia laws that may need to be brought in state court. And so people that violate Virginia laws would only have to pay redress for the one-off violation, even though their conduct is pervasive and can impact like thousands or tens of thousands of Virginia consumers. And so it is just a procedural mechanism that literally almost every other state in this country has, and Virginia is just so far behind.
Can you kind of give us an example of like why a scenario where something can't be addressed here in Virginia, maybe you've had to go to federal court, or even a better situation where you weren't even able to go to federal court because of the subject matter?
Yeah, so a good example, my firm, I can give you 2 examples. So first, my firm handled a case for medical students that had applied to a medical school called Medical Learning Center, and they paid their money for this education. They were told it was approved by both the State Council of Higher Education and the Board of Nursing so that they could get licensed when they completed the program. they complete the program, and lo and behold, they learn that the school is actually had its license rejected or revoked by the Board of Nursing. And so they couldn't get their license. And so they spent all this money on medical school and couldn't get their license. And so we brought a claim under the Virginia Consumer Protection Act for these consumers. And so we could not be in federal court because the company is Virginia-based, the principal of the company was Virginia-based, and my clients were located in Virginia. And so we had to file in state court under the Virginia Consumer Protection Act. And we represented 19 immigrant women who paid money and completed the program at this school and we used the Multi-Claimant Litigation Act to bring it in one case. And we were able to obtain a great judgment for these women. However, once our judgment became public and the Washington Post did a story, we have been contacted by so many other people who have been impacted by this and want our help. But we can't help them because we already represent these women and have a judgment that we're trying to collect. And so it would pose certain conflicts for us to now represent other consumers. And so only my 19 clients will get redress and benefit from the work we did. Whereas if there was a mechanism for a class action, we could have brought this as a class case in Virginia, and every single woman that was victimized by this scam school would now be able to recover. Instead, only a fraction of the people that we represented will be able to recover. And so it is unfortunate that we didn't have the class action mechanism at that time, and only those 19 people can recover. And so
Let me ask you,
it's important.
Yeah, let's assume that we had class action at this point. What would the process had looked different for each individual client, and from a litigation standpoint, but also from a cost standpoint? Like, how would that have been different?
So, at trial for this case, we had to have 19 different plaintiffs testify about their damages, and the trial took much longer than if one person testified and we were able to explain that it was the same thing that happened to everybody else, right? And so we had to spend a lot more time in court to put on our case and our evidence than we would have otherwise had to do. If it was a class action, the only thing that really would have been different is procedurally, we would have had to file one motion called a motion for class certification that the court would have had to rule on. And Virginia's class action bill will mirror the federal statute, which Rule 23 of the Federal Rules of Civil Procedure. And so it'll be the same sort of analysis. Is the class numerous? Can you identify these consumers, who they are? And do they have common issues that impact them, and like common issues for a trier of fact to decide? And then is it a superior way to adjudicate the case versus doing individual mini trials? And then do these individual issues like predominate the case, right? And so in most instances, like this nursing school case, right? It's kind of a no-brainer. Like they all had the same thing happen to them. The only difference is like how much did they pay? Their measure of damages may vary slightly. And so, I think it would have been a pretty simple way to approve, of a class there and get everyone the relief, right, that we were seeking. And so there's a lot of judicial efficiency there. And, now all these other women who we did not represent will have to file their own separate case and are doing that, right? They're filing separate cases. They're going to have to put on separate, evidence. They're going to have their own trial. And it just takes a lot more resources of the court and even of the defendant to do it over and over and over again versus having it done in one case.
And I suspect that for, let's say, a bigger defendant company that happens to be based here in Virginia, if they have the threat of class action, that probably changes behavior a bit differently. Would you agree with that? Yeah.
So a lot of times why we bring class actions is you identify a problem in the marketplace, right? Like we're bringing some cases against landlords that are charging what we refer to as junk fees. And so, we've identified certain, fees that we think are not permitted under Virginia law. And so we brought those cases as class claims. And the goal of the case is to prevent the fee from being charged in the future and refund money for, the prior payment of the fee by these.
What's an example of a junk fee that you think is something that is important?
So, when a tenant applies for an apartment, they understand what the cost of the rent is, right? And they shop around based on their budget for the rent. And so what a lot of these landlords do in Virginia is that when you sign the lease, they then have a list of all these other charges in addition to your rent that you have to pay every month. And so they shift the burden of the landlord to maintain common areas and maintain the premises in like a safe and habitable condition. And they shift that burden over to consumers. So like consumers get charged common area electric. So that means in order to walk to your apartment and it not be dark and comply with like building codes to have a lighted hallway, the tenant has to pay for that, even though they're renting a unit and they're not renting the hallway, right? And so they're shifting the burdens on tenants because who's going to stop them, right? Because they can. And this causes people to pay hundreds of dollars more every month in addition to what they were told their rent was going to be. And so that's just not okay, right? And all it is a profit generator for these people. We've done some cases with pest control fees too. In those litigations, we've learned that the pest control fees, even though it says it's for your dwelling unit, the units are never or rarely sprayed. And instead it's just spraying common areas or maybe like another tenant's unit who complains, but you're paying for that. And even though it's supposed to be for your dwelling unit, and it's supposed to be tied to the cost of the service. But in fact, a lot of these landlords are profiting like 6, 7, 8, 10 times the cost of these charges and using these additional fees as a profit generator. And that's just not okay. And I think it violates Virginia law. And so that's why we're bringing these cases.
Yeah, and I appreciate the housing aspect of it. I suspect that pushback you're going to get, and tell me if I'm wrong, is from the landlord lobbying group saying, look, this is going to increase the cost of rent. It's going to decrease affordability, maybe even supply. What's your response to that? What about like the individual person that just wants to rent out their townhouse, and now you're saying I'm going to have to worry about a class action?
Well, that wouldn't happen, right? Because there's not numerous people who would be impacted by, Jane and Joe landlord just renting out our house. There's just one person there. Like we're talking about large property management companies based in Georgia, Pennsylvania, like Utah, coming into Virginia, snapping up properties, raising rent, adding a bunch of bogus charges, and making Virginians pay extra when they're told one thing about the cost of their rent, and then all these other add-on charges are included. And so that's like the real problem here.
Yeah, and
if we bring it as a class claim under Virginia law and we lose, like they win, no big deal. Like what does it matter? It's not much different, not much heavier lift. It's just one additional motion. And so it's not like something groundbreaking because it's literally available in every other state except Mississippi and at the federal level.
Do you have any sense why Virginia is unique to not have allowed this change?
I think our legislatures have, tried to introduce this bill a little while ago. We have a large financial services and bank lobby. And, I think Governor Spanberger has expressed her commitment to affordability and, the issue of access to justice, I think is really important for people. And so I think that now is the time to pass this bill and get Virginia out of the dark ages as, one of the 2 states that don't have this procedural mechanism. And, all it does is level the playing field. And if there's a bad actor, like, shouldn't we want the appropriate redress to happen to these people, regardless of their ability to pay for counsel? Why should just rich people get redress in situations like this, or just one person that goes and hires a lawyer. Like, it's about fairness in the marketplace, and everyone should want it to be fair, because there are a lot of landlords, there are a lot of companies that follow the rules. And so they shouldn't have a problem if they're following the rules.
You know, and I'll tell you what sparked my interest in this beyond just general interest. You and I were having a conversation recently, and you started talking to me about junk fees. And, you know, and for folks watching, I run a standard litigation practice. We look at individual clients, and you're telling me about costs in the $50 range, $100 range. And I'm just thinking, from a litigation standpoint, it would never make sense for me as an individual attorney to take on that one $50 thing. And what I appreciated about what you guys are doing is it's the creative nature that you're required to look at, because these companies are creative in how they create their profits. I mean, who would think that you would be overcharging and multi-charging individuals for pest control? And I just don't know how that even gets into the psyche of a business company. But I mean, I guess that's the whole goal, is they're trying to create margins where they need to create them, right?
Right. I mean, it's about profit and greed, right? And so a lot of times when you see things happen, like a great example are these quote rent-a-tribe cases where these out-of-state companies come into Virginia, and they use a Native American tribe as a front to evade our laws that our legislatures and like the people in this Commonwealth rely on. And they give loans to people who are desperate for $300, $500, and charge 1,000% interest.
Wow.
And so that woman, the single mother that they market and target as their client or their customer base, she can't afford a lawyer if she is, desperate for a $300 loan. So what is she gonna, like, is a lawyer gonna take a case to, deal with a $300 loan? Like, you would hope we're in a world where we can do that, but there's just not a lot of lawyers for the number of people that have these problems. And so we, because of the federal class action mechanism, we've canceled $1 billion in debt in one of our cases, and got people back tens of millions of dollars that they should not have paid, because, these things are illegal under Virginia law. But we couldn't use Virginia law to enforce it. We had to go to federal court and find a way to make it work under federal law. And so, I think when you understand the types of cases that were, that are impacted by this, it is people just looking for loopholes and looking for ways to, make money and like creative products, right? And so, Virginia is just really just getting in line with the rest of the country. And, we're just behind in this regard, and we need to have this as a mechanism so that.
Let me ask you,
help.
And not to get, sorry to cut you off. Not to get into too much of a weeds of that particular case. How is it that they were using tribal law to get around Virginia law? To help me understand that issue.
So they were arguing that their Native American law applied and not the law of Virginia. And so they also, their contracts waived federal law, and most of these contracts waive federal law. Some incorporate federal law now. But so they were just saying, we're a sovereign entity, like a Native American tribe. And so our laws apply, not Virginia laws. And so that's like, that's how these models are set up. But the reality, like we have one case where it was really run by this guy living in Puerto Rico, some white dude in Puerto Rico was running this whole operation, making literally hundreds of millions of dollars off Virginia and other consumers, and giving this Native American tribe like a 1% of the profits, right? And so, and so in those, and it's like there's a lot of problems like that we couldn't sue under Virginia usury statutes. We had to go to federal statutes because there was no class action mechanism in the Virginia.
We've talked about lending, education, housing. What other industries do you think that having a class action statute in Virginia will allow review of what's happening in our Commonwealth?
I mean, I always joke that it is, there's a lot of other types of law that I don't practice, right?
Mhm.
Like, um, like certain components of like certain like state civil rights type claims.
Sure.
Um, but I do a lot of mortgage related litigation, and
Mhm.
most of that does fall under federal law because
Mhm.
mortgage lenders are exempt from most of our state statutes anyways. Or like any dealings with banks, they would be exempt under most state law claims anyways. So you're really, we're in federal court already. And a lot of the people that you would think would oppose a class action bill, like with the lobby, like mortgage companies, banks, they're already subject to federal law and the procedural
Mhm.
class action mechanism in federal court. So it really won't have impact on them.
Mhm.
Um, and so it's just entities that are regulated under Virginia law.
Mhm.
I can tell you that a lot of entities have arbitration, and usually arbitration agreements include class action waivers. So those entities would, if their contracts are properly written, wouldn't even have to deal with a action
Oh, wow.
mechanism anyways. And so it is really just a smaller subset of, who can be, brought under these statutes. But it is really just getting Virginia in line with the rest of the country. Like
Mhm.
and making sure that there is a mechanism for access to justice for
Mhm.
consumers and those who may not have the ability to, hire counsel or to make the court process more efficient for everybody.
I would consider our recent elections here in Virginia a blue wave. I think there's going to be a lot of Democrats coming. There are a lot of Democrats coming in the legislature. We have a big leg up in that regard. Do you feel confident that this statute will pass? And what do you think the biggest pushbacks will be from whether Republicans, independents, or maybe some Democrats may push back as well?
I believe this statute passed. I want to say it passed and it was vetoed by Governor Youngkin.
Yeah, I think 2024. Yeah.
And so you would think that it would get through, and you would think Governor Spanberg would think it's important to provide,
Mhm.
um, the access to justice here. And so, but I do think that it should be a no-brainer, in my
Mhm.
opinion. And I just, I'm optimistic, cautiously, of course, that it'll be passed and signed by the governor.
Okay. We're both lawyers. I do personal injury. I hear ambulance chaser all the time. It's part of the job. There are going to be some people that are watching this and seeing two lawyers talk about class action, and they're going to be thinking, "Isn't this a way just for class action lawyers to get rich?" What's your pushback to that? What's your response to that? Maybe it's not a pushback. Maybe it's a discussion.
So I guess I would just say if there's no claim and there's no case and these people haven't violated any laws, then they'll win
Mhm.
and I'll lose. And so it wouldn't be a problem. But if someone's violating the law and taking money from people that they shouldn't be taking money from, and thinking that just because they're poor or that they're less sophisticated and they'll never hire a lawyer and they'll get away with it, those are the people I stand up for, and those are the people that need this class action mechanism.
Mhm.
And I'm not worried about the perception.
Mhm.
Like, I know that the reason we do these cases and why this matters is to fight for people who don't always have a voice.
Mhm.
And I think class actions in Virginia will allow us to do that in a more effective manner. I mean,
Mhm. Mhm.
the case that we had where all these women, these are hardworking women working two jobs and going to school to get a better life for their family. And we only could help a tiny fraction of those women. And all of these other people will never get the redress that my clients will, because we could not bring them as a class claim. And the courts will also have to go through dozens, if not hundreds, of additional trials for each of these women's cases if they want to get redress, when it could have all been done in one court case at one time.
Mhm.
And if you don't think those women should have gotten their money back and had a mechanism to recover, then I don't think I'll ever convince you that it's a good idea.
Mhm.
But I know that the people that will benefit from it, some lawyers certainly may benefit, but it's really about the people who are being charged these fees, putting a stop to these problematic practices and punishing bad actors. And if
Mhm.
you're not a bad actor, I don't know why you would care.
Yeah, and when I hear pushback, especially in class actions, when you're talking about multiple trials and all that, we the taxpayers are paying for the judges, for the bailiffs, for the technology, for the space. When there are other matters that should be addressed in our local courts that are being taken up, because if the individual is lucky enough to find somebody like you, and that's a big if. I send all my cases to Kristi because I don't know a whole lot of quality. I mean, I'm sure there are, but a lot of quality attorneys in your space that do it creatively as you do. And that's the reason, you're so well known throughout the state. So if you're looking at it from a community standpoint, even if you don't care about the individual claims, look at it. Your tax dollars are going to spending those hours in courts. If you are,
but it's also too, like, it delays things, right?
sure.
If the courts are doing 100 trials, the
Mhm.
same trial over and over, that delays like someone else's divorce proceeding or getting your traffic matter
Mhm.
adjudicated or whatever else it may be. Like, it delays everything because there's only a finite number of resources.
Yeah.
And so it's about simplifying the process.
And I will say, coincidentally, I would happen to be over at court when you guys were trying this case. I just happened to walk in. I think that I was trying to find a particular judge, and I walked in, and I ended up sitting through the closing. And the defense had no actual defense. I mean, it was just, and I don't mean to overstate this, it was nonsense what the arguments were as to why the defendant school owner wasn't at fault here. And so you all had to go through this whole process and spend this money and time when there was literally no defense. I mean, it was absurd to see that in court. I mean, you obviously did a great job, but like, it's just tragic that had to go that far.
Yeah, I mean, it just delayed my clients from getting, their money back. And, that defendant chose to spend money on hiring a lawyer, then give it back to these women that she had victimized. And she chose to ignore the orders from the Board of Nursing and the State Council of Higher Education and just continue to operate the school that would not benefit anybody because she wanted to make more money. And so we had to put on the trial. Everyone had to sit there. Jurors had to attend. Like, people had to be there because she wanted her day in court, and she's certainly entitled to her day in court. That's part of our judicial system. But it could have, if I don't think she had much of a defense either, obviously. I guess the jury agreed with us there too. But yeah, it's not just consumers or, plaintiffs wasting resources. Like, that's part of it. So.
And I think that the bill has been pre-filed, but I hadn't, we're doing this on the 13th. I think it would have been filed yesterday or today. If you had a magic wand and you could be the one that writes the bill, is there anything, if you're talking to a legislature right now, they're looking at this pre-filed bill, is there anything that you would want to highlight to make sure it's not missed in the bill or maybe overlooked, or any tips just there? Or maybe that's too broad of a question.
No, I mean, actually, I think that the sponsor of the bill, Senator Suravel, really went to a lot of different constituencies and worked with a lot of different parties to get a lot of feedback and buy-in prior to session even starting. And I think the bill largely does mirror Rule 23, which is this federal civil rule procedure on how class actions are done in federal court. And so nothing in the bill is like novel, in my opinion, and nothing is really controversial. It is simply like putting Virginia in line with the federal court system and also the rest of the country. And so, it's almost like we're way behind in this regard. And so there's nothing that I think is particularly novel or groundbreaking, although for Virginia it will be, but it's just because we're so behind that I think it's important that it get done at this time.
Yeah, if you're being led by Texas and Alabama in our judicial system, you want to take a closer look at what's happening. I'm going to not keep you much longer. Anything else that you think that would be useful to think about as Virginians, as legislatures are thinking about this bill?
No, I would just say that, it's really just one more motion as part of a case if this is a more widespread problem, and the burden would be on the plaintiff to show that it is. And if a class is certified, it's important for people to understand that the defendant can win and win as to everyone in the class. And so if there's no problem and whatever the practice being challenged is, the fee, the violation, whatever it may be, and the defendant doesn't think it's a problem, it's no different litigating as to one person than litigating as to class, except if a class is certified, you get that ruling for everybody, right? So there's a mutual benefit here if the challenge practice is not a problem. And so there's no point in doing it in a one-off situation.
Yeah, and I will say for folks watching, they hear about frivolous lawsuits. One misunderstanding is they think that there's like no recourse if something is truly frivolous, when the court has the ability to sanction folks and has sanctioned folks when they bring truly frivolous lawsuits. So that's really giving the court the opportunity to make the calls rather than, just litigating it in the media and social media, that kind of stuff. So something important.
Right. And the other thing too, James, is like a personal injury lawyer. If you're bringing a class claim, for a consumer or some other like civil rights type violation, a lot of times those are taken on a contingency basis. And so most lawyers will like heavily vet a case to make sure that the practice does indeed violate the law before they take something like that on, because they're not just being paid to go through the motions. You want to bring a case that is meritorious and that will warrant the efforts to proceed in that manner. And so, a lot of times I think it's important to acknowledge that, there's risk. And so like you only want to bring a case that has merit and that clearly shows a violation of a Virginia law in that situation.
Yeah. And I do get a lot of question about what is a contingency fee. Can you just, for the viewers, explain that simply? What does that mean?
Yes. So from a contingency fee it just means that when the lawyer agrees to take the case on, that they're not being paid by the consumer. They would only be paid if they prevail in the matter and that they get some sort of financial benefit from the entity that they sue. And so it's no risk for the plaintiff and no benefit for the lawyer if they are not successful.
Yeah. And I turn down a lot of cases that are risky, because as a contingency fee lawyer, as a small firm, I'm paying literally out of pocket. So that's also a huge check on, so-called frivolous lawsuits. We don't want to pay money out the cases we think are going to lose. I mean, it just doesn't make any sense from a business market. If you're a market person, this is market controlling, right? So, okay. Anything else you want to add? I've already taken about half an hour of your time, and I really appreciate it. So,
no, I think you covered everything. I just hope this gets passed and Virginia gets in line with the rest of the country.
Yeah, and I will put your contact in the show notes. So if any folks have questions about consumer law, about class actions, obviously, Kristi is again, her firm is nationally known. I'm just really appreciative of you taking the time, because I know you're super busy, to come on and talk to us. And again, I'll put your links to your stories from Planet Money. And I was starting to watch the other one. Was it PBS that did a story on you?
Bloomberg.
Yeah. I think I saw that. I'll put that in there as well. So thank you for your hard work.
I haven't watched it either.
Oh, you haven't watched it either?
It was too long.
Well, those are both awesome. Just to be in the subject matter is pretty awesome, especially for nerds like us. So thank you again for all the work. And if you need anything, reach out and I'll let you be. Okay.
Thanks for having me, James. I appreciate it.
Of course. Happy New Year. Bye.
All right. Thanks. Bye.